I'm Gerald Green from Memphis, representing the appellant, Sahara Daycare Center. I'd like to reserve 3 minutes. Please.
3 minutes?
Yes, please.
All right, sir, you may proceed.
Your Honors, I hate to start off with something was from a position of weakness, but I made a gross mistake in my brief, and of course the appellee caught me on it, Judge. It's the worst mistake I've ever made, and maybe I've ever seen. I included something I wrote for the Court of Appeals in this brief. I don't know if I was cutting and pasting or whatever, but I still haven't gone back and discovered how that happened. But I wish the court would disregard, well, certainly omit any references to that, the post-conviction, and let me strenuously argue my relevant and hopefully meritorious parts of my brief.
All right, sir, you may proceed.
All right. Yeah, and our appeal centers around actually a default judgment entered after the proof was taken, after trial. There were some discovery disputes in this matter. Along the way, my client was sanctioned for discovery abuses or her limited revelation of some of the discovery documents of production. Now, in her last round of production of documents, she produced a matter that had not been produced before. It was a separate bank account. There were funds from an SBA loan in it. It wasn't an operating account, and it represented funds from a loan. And Judge Wagner computed that as an asset of the business, which a loan, I think, shouldn't be calculated as an asset. And so that caused the division of profits and damages to be miscalculated, we think, and we wish the court would look at that, her holding that was an asset. Additionally, I think the defendant, let
me ask you, Mr. Green, in the order itself, does the trial court describe the SBA loan as an asset? Because as I recall from looking at the order, there's no mention of the SBA loan. She simply indicates the amount of money that was in the business account around the time of the dissolution.
Yes, Your Honor.
So where do you take this argument from where she says the SBA loan is an asset?
Well, you notice in her order, she refers to 2 separate accounts. One account, business operating account, and then another account. And during the argument and during the case in chief, Your Honor, it was testified to that was money from a loan. We didn't count it as an asset, and that was my client's primary reason into the court saying why she didn't disclose it at first, because it wasn't an asset, or it wasn't a regular operating account. But you're saying that from the order, how do I get that?
Right.
Well, she calculated it in the finding of facts, in her evidence, statement of evidence. I think she says, we testified that it was a loan, the SBA loan. And the appellees never disputed that. You know, I think another point we want to raise is that I think the appellees used the discovery disputes as a red herring and took the judge's attention off of the merits of the case and said, well, they haven't complied with discovery in a forthright way, and it took her attention off of the real crux of the case, which was a partnership breakup. And as I say, she held the motion on the default, motion for a default judgment in abeyance to after all the proof was in. And it's as if the credibility, and she decided the case in favor of the appellees based on a default. And actually, the default, after we had put on the proof, really took the rug of any kind of raising a preponderance of the evidence argument. If she had to weigh the evidence, there was no preponderance. But if you default, well, you don't have any proof. It's all plain as proof.
I'm not sure what you're arguing, Mr. Green. Are you saying that the court erred in granting the default judgment?
In the manner, yes, in the manner.
Okay.
And I think the sanction was too great. After you've argued a case and put on your proof, and then you say, well, I'm gonna default you.
Or didn't she advise the parties at the beginning she was holding that matter in abeyance until she heard the proof?
She did, Your Honor.
Would it not have been reasonable to have assumed that she was trying to determine how important the failure to produce discovery was before she imposed a sanction?
I do agree with the court there. But Judge Stafford, in an opinion you wrote recently, you said procedure has to be followed. And I certainly can't cite the case right now, but there has to be a certain procedure. And of course, if she had granted default judgment before trial, it certainly would have changed our trial strategy or decisions on whether to go forward or not.
I don't believe that opinion said that you have to rule on it before trial, do you?
I don't recall it saying that, no, Your Honor, I don't. But, we certainly think that sanction of default was too harsh in this matter. She did produce it, albeit late.
Okay. How many opportunities did the trial court give your client to produce the requested discovery?
I think at least 3, Your Honor. But we were sanctioned for the second one of inadequate disclosure, and we paid a sanction for that. So I think that punishment was complete there.
So what else do you suggest the trial court could have done?
Well, certainly a sanction less than default. Perhaps another sanction of attorney fees and cost. Or maybe
Did she warn the parties? I mean, the other side had requested a default judgment, I believe, initially from the first failure to produce discovery, had they not?
My memory fails me if they asked for default in the first one. They asked for sanctions, but I know they asked for default in the second one. It asked early on.
Okay, so there was fair notice that that was being requested, and the court, that was basically one of the arrows in the court's quiver. Would that be accurate?
That would be accurate, Your Honor.
Okay.
But under there's case law that says that the sanction of default is only to be used in contumacious. I think the word is contumacious conduct. It's never been a finding of contumacious. I don't think contumacious conduct. I think repetitive doesn't arise to contumacious yet. As a matter of fact, the case that I think the appellee cited a case where somebody took a document from a deposition and hid it. It certainly doesn't arise to that, yeah. And my client did produce it. If she never produced it, just think we never know about it. So she was forthcoming in producing everything, even though she didn't believe that was relevant to the case.
The production that you're talking about was not until the day of the trial. Isn't that right, Mr. Green?
No,
She finally produced the bank statement that showed the $70-some thousand
No,
in the
it was
account.
produced prior. It was produced prior to trial.
All right. In
produced
regard
in the
to
last
your
one.
argument that the failure to respond to discovery was not contumacious, didn't the judge find that this was a willful failure, which is really the same thing? And I notice in looking at your brief, you don't cite a single case that supports your argument that the conduct here doesn't warrant a default judgment by the court for failure to respond to discovery. You seem to recognize in your brief that that's one of the options available to the court, but you cite no case that support your argument that under the facts here, that should not have been granted.
Yeah, but I do cite cases, I think that, say that's almost the ultimate sanction of default. There are many less hurting, should I say, less prejudicial sanctions than defaulting a person, especially after you put on your proof. It's as if, well, I decide who I'm going to believe, now I'm going to default them, or I will pull the rug out of them, and I don't have to weigh the evidence now. So we just think that in these circumstances, that was not proper, and we asked the court to grant us relief. I think that's it. Thank you, Your Honor.
Thank you. Hear from the appellate.
Good morning, Your Honors.
Good morning.
My name is Paul Prather. I practice in Shelby County. I represent the appellee, Janice Deloach, in this case. With regards to what Mr. Green is speaking about concerning the discovery sanctions, we filed this suit early in 2021. We served discovery upon them on May 5th of 2021. We reached out to Mr. Green concerning their lack of response to the discovery and filed our first motion to compel on August 2nd of 2021. We had a hearing on that. It was granted. They still did not respond. We filed a second motion to compel on September 14th, 2021. They again turned over some documents, some were relevant, some were not. They did not turn over what we asked for. We filed a third motion to compel along with a motion for default judgment. Now, Mr. Green would have the court believe that they didn't know anything about a default judgment or anything like that. We actually had a hearing on that, and the judge actually denied the default judgment. Now, with the second motion, she did sanction them to pay us $250 in attorney fees. She again told them they had to turn it over. We eventually set this for trial without everything that we needed. Now, what Judge Armstrong is referring to when he talks about turning over the discovery on trial day, after, I believe it was the third motion to compel, they turned over one bank statement for account we had not previously seen. Now, on the day of trial, we're hearing the default judgment. Ms. Camara reaches forward with an envelope filled with account statements and tries to give that to Mr. Green to have him give it to us. Judge Wagner stopped her and said, whoa, 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 what is that? She said, this is the rest of the discovery.
Is all this in the record?
Some of this is in the finding of facts and conclusions of law, the statement of evidence. So she excluded them from being able to use any of that for the amounts of what would be split up and upon the dissolution of the partnership. Judge Wagner bent over backwards to give them opportunities to comply with discovery, in fact denying a motion for default judgment that we filed. Now, on the day of trial, she found that Ms. Camara willfully, and I would say contumaciously, did not turn over that discovery. She defiantly told the judge, I didn't turn it over because they weren't with us. I believe that the default judgment was entirely appropriate in this case, and that it was an operating account. Mr. Green would have you believe that it was not an operating account, but Ms. Camara testified that it was an account that had funds, not just the loan money, it had other money that went in and out from the daycare, and she did not disclose that account to Ms. Deloach. Ms. Deloach was not even aware of that account until we did discover it in the discovery process. Mr. Green did not pray for relief at all in this case. He asked for post-conviction relief, which is entirely inappropriate to this court. This court doesn't grant post-conviction relief. He hasn't even asked the court to do anything, and we would ask that you would find for the appellee, Ms. Deloach, and I will, unless there are other questions from the court, I will rest on our written materials.
Let me ask you, the statement of evidence.
Yes, sir.
Does that include the evidence that was struck, that was presented by the appellant?
It mentions it. It doesn't include the actual account balances, I don't believe, from memory. But the evidence that was struck was largely account statements.
Okay.
Thank you.
Thank you.
Mr. Green? Believe you- Okay, all right. All right, gentlemen, thank you for your arguments, for the briefs you filed. We will review the record and the evidence